My name is Ned Foley, and I am privileged to direct the election law program here at The Ohio State University. And we have decided to gather together to assess where the electoral process is right now as we're going through some unusual times. We've got a great group of people, some of whom will be joining us in the middle of this discussion, and it's going to be a very free-flowing discussion. This is not scripted. This is not designed to have presentations. It's just almost a brainstorming session. And to lead us and to moderate us will be our Deputy Director, Steve Huefner, my friend and colleague who has done a brilliant job with this sort of thing before and will do so again today. And as before, I'm instructed him to make sure that I'm muzzled so that I don't speak too much so that we get to hear from our great group of people. So please, Steve, take it away.
Thanks, Ned, and it's great to be with each of you, and we welcome those in the audience who are observing our conversation today. As Ned said, we've done several of these now this election year, and beginning back in May, I think it was, and then again a few days before the election, and now this post-mortem, if you will. And each one, the cast of characters has been a little different, just depending on availabilities primarily. So we are delighted that some of you are returning, and some of you, or some of the people who may be with us today, may have been doing this for the first time today. We are just interested in thinking about where things stand today. And as those of you who've observed these conversations previously will know, those of us in this field have been thinking from early this year about the possibilities that there might still be unresolved issues in the presidential election in particular at this point, and wondering how those would play out. But nonetheless, the circumstances we are in now are not exactly what any of us might have anticipated, and there's plenty to talk about. We are at the point where, just as the normal part of the process, about a dozen of the 50 states have now certified their results. We will see certification in theory in Georgia tomorrow. Early next week, we'll get Michigan. It'll be the following week before we get Arizona and Wisconsin. So that's just part of the timetable. And meanwhile, we've seen litigation in a number of the battleground states, as well as requests for recounts beginning in Wisconsin today, and Georgia completing one now that started a few days ago, and so forth. So again, lots to talk about. Last time we did this, we asked each of the participants to just tell us briefly what was most on their mind, and we did that in reverse alphabetical order. We're going to do the same thing today to start, but we'll do it in alphabetical order from top down. I do want to say just before we begin that the format for this is intended as a conversation among this group of about a dozen election law scholars from around the country. And so it's not our plan. We haven't activated the question and answer feature. We've just got an hour or so to make the most of the time we can as this conversation, and we're delighted to have many people observing it. But let's get to it now and just see what this group of people is thinking about where we stand. So I think in terms of alphabetical order, want to start with Rebecca Green from the William and Mary College of Law. Rebecca, what's top of your mind today?
Thanks so much. And thanks so much for having me. This has been a really useful group. So I guess I do want to start with this. One of the ways that the Trump campaign has tried to delegitimize the results is to claim that observers have not been able to adequately oversee the process. And as I've said in the past, I think it's critically important that election processes be transparent, despite whatever challenges COVID presents. And I'm all for allowing as much access as circumstances allow. That said, something that has really been lost in coverage about observers so far is the many checks and balances built into the process in every state to ensure process fairness and legitimacy. Observation is one layer, but every state has multiple other layers of protection built into how votes are counted. Some states do this by having both parties represented at counting tables. Some states have what they call inspectors that are responsible for confirming each stage of the counting. And the idea that the absence of an observer means that funny business has been allowed to take place is patently absurd. State legislatures and election officials in every state are well aware that some actor may try to delegitimize results, and that the entire system is therefore constructed with that in mind, with multiple layers of checks and balances. So, the idea that making observers stand back at a safe distance means that the process therefore can't be trusted is offensive to the intelligence of the people who design our election processes and who take every precaution to make sure that post-election processes are safe, fair, and secure. So I just thought I would start with that, that rant.
Great. Thanks, Rebecca. So next I'm going to turn to Rick Hasson of the University of California, Irvine School of Law. Rick?
Thanks for having me back. It's unfortunate that we all have to be gathering here at this point. I think it is profoundly depressing what the last week especially has shown. Certainly when you have a close election or when you have concerns about how an election is run, it's perfectly appropriate to go to court. That's perfectly appropriate to demand recounts. The media does not have any official role in calling elections. And so there was a space and time for the Trump campaign to come forward with whatever evidence it had of wrongdoing or of mistakes and try and show that these mistakes were so profound that they could alter the outcome of the election. That's what we saw 20 years ago in Bush versus Gore, an extremely close election in a single state that was dispositive for the Electoral College outcome. And it took a little over a month to resolve that dispute, and it was resolved in court, and you had leading lawyers making credible claims, some stronger than others, for how to handle this very close election. What we have now is a completely different situation. We have a situation where the election is neither close in the Electoral College, nor particularly close in any state. We have a situation where there has been no widespread fraud found, or even small cases of fraud, and very few glitches in how the election was run. The biggest glitches I've seen so far involved some failure to count some ballots in 2 counties in Georgia, neither of which will be enough to come close to changing the results. And we have a kind of 2-track process. On the one hand, we have the president and some of his legal team, and I use the term legal team very loosely because they're not really making legal arguments, making arguments in public that are convincing millions of people without evidence that our election is being conducted in a fraudulent way, and that Biden is stealing the election. And that we just learned now from a press release that it's a conspiracy that involves George Soros and Hugo Chavez. So, I mean, really off the rails, wacky stuff. And what we're seeing in court is the worst lawyering I have seen, at least I've been following the Pennsylvania case, the worst lawyering I've ever seen in an election law case ever. And arguments that are being made that are supported by neither law nor facts, an attempt to disenfranchise voters. And on top of that, you have what appears to be a political effort to try to strong arm state legislators to come up with an alternative slate of electors in an attempt to try to derail the will of the people. This is about as abhorrent kind of behavior in terms of democratic norms as we've seen. I don't think it's going to work, and we can talk about that. But I feel like it's a very sad moment for our democracy that you have the president who has lost his election trying to drag down the country's election system along with his own presidency.
Thank you, Rick. Next, we'll turn to Justin Levitt of the Loyola Los Angeles College of Law. Justin?
Yeah, so I'm going to share the same upbeat tone that you heard from both Professor Green and Professor Hasson, unfortunately, and I don't disagree with anything that they've said. So to try and keep this in raising a little bit of something that isn't just in the nature of repeating. In 2016, we were attacked by foreign military units. That has been repeatedly proven. The election system, the election process held, right? They didn't actually attack the election infrastructure. They didn't attack voter registration. They didn't attack tallies. They didn't attack any individual ballots. They attacked the weak link. They hacked us. And I have been very concerned that this year, this cycle, and not just this year, actually, that's a misstatement. For the last 4 years, the calls have been coming from inside the house. So now we don't need a foreign military unit to attack us. We have the chief executive doing exactly that. Again, not through the election processes or procedures. We can and do have debates about how fair the election laws are, who they embrace, who they leave out. Still plenty to fix on that notion. But given the ridiculously low standards we set for ourselves, the election that we held this time was smooth according to the laws in place going into election day, right? No major problems, again, as in 2016, with the systems that we set up for ourselves. But again, the problem is us, and particularly a concerted attempt by powerful figures to feed misinformation and disinformation that really increase the difficulty that we have in governing ourselves. It's even more dangerous this time than it was in 2016. In 2016, there was misinformation about facts. There was an attempt to inflame sort of our deepest political tensions. Now it's really about democracy. It's about trying to set up the conditions where half of the country believes that there are only two possibilities. Either they win or the election's stolen. And that's not a democracy. There has to be a third possibility, which is that more people happen to agree with an opponent than agree with you. And if that possibility doesn't exist going into an election or coming out of an election, then we don't have the rule of law governed by the voice of the people. I fully agree with what I know Rebecca said in the past and what Rick just said here, and what I expect others will say, that we will have a new president on January 20th, that the system will hold, that the votes of the people will actually be recognized, and that the process will serve to inaugurate the person that a plurality of the voters in a majority of Electoral College states have chosen. But we may well be making the country ungovernable in the meantime. Because if half of the public believes that we didn't just have an election, I'm not sure how that's consistent with anything that happens after January 20th. And that's really where my real concern is.
Thanks, Justin. Nate Pertley from Stanford.
Well, thanks again for organizing this. Let me pick up a little bit where Justin left off. So before Charles and I started the Healthy Elections Project, Stanford MIT Healthy Elections Project, I was and still am head of the Cyber Policy Center at Stanford. And I thought that most of this election I would be dealing with disinformation, political advertising, specifically online. And instead, when the pandemic hit, moved to start thinking about the election mechanics issues again. And that's what we spent most of our time up through the election doing. Now, I think we are in this period where we're trying to deal with the sort of information war that is occurring before us. And it's occurring in several different settings. I want to start by, I'm preaching to the choir when we have law professors on here, but I want to start with sort of 3 cheers for courts to begin a little bit, which is sort of, you wouldn't necessarily have predicted that the courts would have performed as well as they have in the post-election period or even the pre-election period. Republican and Democratic appointees, some elected, some appointed, have been very, not just professional, but very legalistic, in the way that they have approached these cases, what you would expect. And so all the cynicism toward, partisanship and the judiciary, I think, has not been borne out. Of course, there's still time for that. It's still possible at whatever level, but let's just pause and reflect on the resiliency of that aspect of our system to weigh the competing arguments that are presented in court. And this is, again, to tie it into the disinformation research, right? One can lie on Twitter quite easily. It's harder to go, if you're a lawyer, to do so in front of a judge, right? And so when a lot of these lawyers have been pressed to say that they were trying to demonstrate that there was fraud or to allege very particular illegality, they often stumbled, right? Or they thought ethically that they couldn't do so, and hence you see also a lot of these law firms withdrawing representation. Having said that, let me just by way of scene setting, say the way I'm thinking about what's happening right now, which is that I'm thinking about it in sort of three different, I guess, locations or arenas. First, you've got the litigation that's going on, particularly in Pennsylvania, but also in Nevada, some in Michigan, regarding sort of illegality in the casting and counting of votes. Right, some of these are on the observation cases, as Rebecca was talking about. Some of it is about equal protection arguments in Pennsylvania and elsewhere. In Nevada, it's also about these the way they verified signatures, and it looks like Georgia, there might be a similar kind of lawsuit. So that's one arena which has not proven terribly successful for the Trump campaign. The second are the recounts, and so the recounts in Georgia and in Wisconsin are, stuff is going to, recounts never match the original count. So we will see some problems there. And then the question is, how will that be amplified? And then the third is what I'll just call the sort of extraordinary moves to try to deal with the state legislatures. So the most concerning thing today was the invitation, I guess, to certain Michigan state legislators to come to the White House to talk about, what they might do that might have to do with certifying a different state of electors. Let me just conclude with something that I think is on a lot of our minds as election law people in this, which is, it's very hard to figure out in some ways what our responsible role is in dealing with some of the sort of novel claims and novel strategies that are being pursued. How much attention should we be paying to the possibility of constitutional meltdowns and the like? And do we feed that kind of hysteria? And so I'm trying to say that all of these worst case scenarios are really very, very unlikely. But even by talking about them, we add some fuel to that fire.
Right. Thanks, Nate. So let me turn next to Rick Pilvis of NYU.
So one of the things that is so tragic about the situation we're in now, and this is not the major tragedy, I think the issues that Justin raised are the bigger concerns going forward after January 20th. But one of the tragedies is that we are not able to celebrate what turns out to have been an unbelievably smooth election under some of the most difficult circumstances. And that all of the various things we worried about in advance of the election, including some that have been discussed here, did not turn out to be issues. So some of the ones I can just think off the top of my head, there wasn't a problem with foreign interference with the election, let alone cybersecurity attacks. There weren't massively long lines on election day. There were some at the beginning of early voting, but that's completely reasonable because no one really could have anticipated the volume of early voting on those first couple of days. And people had lots of other options if they didn't want to vote on the first day or the first 2 days of early voting. We did not have significant delays with the mail service. We don't have significant numbers of absentee ballots that are being rejected. We don't have large volumes of absentee ballots that are coming in after the election deadlines. We did not have major confrontations at the polls. There were a few. We did not have a shortage of poll workers, and all of the young poll workers who replaced the elderly poll workers who weren't willing to serve, we were worried about how well trained they would be and how they would handle problems at the polls. That didn't turn out to be a problem. And then it's not just the judges that Nate mentioned, but one of the things most of us have criticized for years is that we have these partisan elected officials like secretaries of state and other partisan officials administering the system. And, for the most part, almost to a person so far, now we have certain controversies about what's going to happen with these canvassing boards in Michigan. But up to this point, these secretaries of state across the political spectrum have performed in incredibly professional ways. And that has not turned out to be a major problem here. And so we had to deal with this massive volume of absentee voting. We had to deal with all the public health issues for in-person voting. And we should be at a moment where we can look back at that and sort of celebrate how well we managed to do this. And of course, all of that's being lost in the controversies that have been spun up post-election with essentially no credible factual basis. And it's not just the people who believe the election is stolen, who, because of the president's promoting this view, but I think it's even people who don't think that, but are not able to kind of see through all of this to look at what we just accomplished and kind of celebrate it. It could have been a great moment, actually, in hindsight, for the American election system and for American democracy. So that's another tragic aspect of where we are now. But I agree with Justin. I think the biggest concern is not what happens between now and January 20th, but how what has been happening and what will happen between now and January 20th are going to make America increasingly ungovernable, increasingly divisive, increasingly on edge. So let me stop with those comments.
Thank you, Rick. Charles Stewart, our political scientist in the group from MIT.
Although Nate and Rick will also point out that they're also political scientists. So I've made that mistake before, but I'm the one non-lawyer in the group. And so I'll just add this. My thoughts at a high level are, I think, a linear combination of everything that's been said so far. I have nothing to disagree. The only thing, the thing I would add as the political scientist, and I'm just noticing what's different here as opposed to the past. I've been involved in a lot of election disputes where the question has come down to kind of the numbers and the election forensics. And so, for instance, 2000, when I got in this business and analyzed, the performance of voting machines. 2006, when there was the dispute in the 13th Congressional District of Florida, where there was a failure of the DRE, the electronic machines in that district. In both of those cases, a problem was identified, weird numbers were adduced. There was basically a scientific process of discovering that there was not only something to the numbers, but there was something broader than just the numbers. And that also there was mechanisms involved that were clearly understood and actually in many cases agreed to by parties to both sides of the election dispute. And which is very different from what's happening here. And this is just my way of saying that I'm being very struck by kind of the how evidence-based courts are. Also struck by the number of calls I'm getting, for instance, to talk about the so-called 450,000 votes that have been flipped or reproduced or stolen or something. And the number of fact checkers who call me up and say they have this 450,000 and here's the mechanism, and it's different from this other mechanism. And how I've seen the 450,000 in a footnote someplace, but I've not seen any imagination of a real mechanism claimed in a court. And so this is just a small way in which I'm just noticing that the courts, I'll take a little bit of maybe there might be something slightly different from what Rick had to say, because we are going down a path in which we may also add the courts as a way of at least being fact-based and being something else to at least celebrate at the end of this long road, although I take the rest of the point that other things that we should be celebrating are going to be obscured. So just to say, I would love to see an empirical claim that could be tested, and yet to see it yet.
Thanks, Charles. I'll turn now to Franita Tolson from USC.
Hello. I agree with much that's been said, but I do want to make one point. I do think one thing that I've been sort of grappling with this week, as we are 2.5 weeks out from Election Day, and we're still dealing with litigation that clearly has no merit, and these wide-ranging claims of fraud, is that I think we have to grapple with the fact that what we're seeing is a massive failure of civic education in this country. And part of it, I think, has to do with the fact that we are not affirmative in our messaging about the importance of voting and political participation and transparency in the system working. For a long time, we've been on the defensive, right? So when there are wide-ranging claims of fraud, the response is there's no fraud, the system works, but we haven't been affirmative in sort of giving people a clear understanding of what goes on in the process. And I think that's something that we have to be more aggressive about moving forward, in part because the fraud claims have sucked all of the air out of the room. It's not, this presidential election cycle is not the first time that these claims have been at the fore. And so I think part of the lesson of this election cycle is to understand that we have to be more civically engaged, and we have to be more affirmative in our messaging about the importance of political participation in democratic norms, and emphasizing transparency in the process, and not simply in response to claims of fraud, just as a general matter, because people don't have the same civic understanding that they had 30 years ago.
Great. Now, we've also had Michael Morley from Florida State join us, Lisa Mannheim from the University of Washington, Josh Douglas from the University of Kentucky. Rather than ask each of them to do the same thing that we've been doing since we started, I'm just going to invite them to join in when they want to at this point, but thank them for being part of our conversation now. And I'd like to throw back to the group the question that a number of us have been talking about, which is really, as a community of election scholars, what is our role now? What is it that we can best do to help our fellow citizens understand where we are and move forward, whether it's between now and January 20th or after January 20th? I mean, I think we're all wrestling with that question. I'm wondering, other than all the media hits that so many of us have been doing, what else is there that we as a group might consider doing? Justin?
Go ahead, Justin.
So I'll just take one opportunity, and that is it's fighting against our role in a little way as what people perceive law professors to be, and actually leaning into what I suspect we all do in the classroom. And that is some of the controversy and some of the contest comes from a perception in the public that lawsuits are magic, that if you just say the right spells in the right form of Latin, that stuff happens. And that has caused the public to give far more attention to the fact of lawsuits and the fact of litigation, embracing contestation as its own end than any of these post-election lawsuits actually deserve. I think that comes from, it's not just us, obviously. TV dramas relish, there's natural drama in litigation. There's a reason that there's an awful lot of TV drama around the litigation process. There's a reason there's an awful lot of movies that focus on a pivotal court hearing as a final event, even one that Rudy Giuliani cited this morning, apparently. My cousin Vinny was a feature of the press conference he just gave, understandably, it might seem. But I think we can help debunk the notion that lawsuits are magic and help remind people about why we have elections and why we have litigation in those elections. Elections aren't sports contests. They exist to actually determine the will of the electorate who we want to govern ourselves. They're the way that we make the world we want to live in together. And lawsuits are dispute resolution for real disputes within that process. But that's it. When there is no real dispute, lawsuits don't do anything. And the fact that you happen to say some magical words in Latin doesn't actually automatically produce a final result. There's a lot of in between that gets there. And I think the more we can help people understand what elections are for and what litigation is for, that may help people come to terms. It's not going to solve anything, but may help people, may inform the environment where people are perceiving what's going on.
So Rick Hansen, why don't you speak, and then we'll go to Josh.
Yeah, I was just going to say, in line with what Justin is saying, that it's important to explain in context how aberrational everything we're seeing is. This is just not like a normal election contest. This is not like Franken-Coleman or Bush versus Gore. The claims are not substantial, and the claims that are being made in public don't match the claims in court. So I think we have a fundamental truth-telling process, and we have the context. You know, I was attacked last night by Jenna Ellis, who's one of the people running the Trump campaign legal team. You can't be afraid to stand up to people who are spouting nonsense and just speak truth to power. And I think now is the moment for us not to shy away from doing that. And I'm sorry I have to leave all of you for another engagement. Enjoy the rest of your discussion. Take care.
Thank you, Rick. Nice to have you with us. Josh?
So I want to reiterate what Justin said, but actually make it a little bit stronger, which is I think we should be advising media outlets that they either should not be reporting on these lawsuits, or that the headlines and leads and entire context needs to be that this is not normal, and that there's no chance of this actually changing the outcome in terms of a court of law. And I was really disturbed, the first week or so after November 3rd, just reading some of the headlines, which said things like, Trump brings lots of claims, or Trump succeeds in one lawsuit but loses the others. And, that one success was, okay, poll workers can, or poll watchers, whatever, can stand 6 feet, which is what they're already doing, but there's a court order now to make that happen. And I think journalists have a really important role in this. We as a community have a really important role in advising the media about how to tell that story in a way that is proper. And this is not a time for both sidesism, and we need to really push back on this notion that, well, we're not going to be seen as credible unless we're both sidesing it. And along those same lines, it's sort of pivoting a little bit, but I think the other thing perhaps we can do as a community is highlight the unanimity among election law scholars of all different viewpoints to how crazy this is, how unprecedented it is, and how much has no likelihood to change the outcome. I mean, we have professors on this call and otherwise who come from very different viewpoints, and yet we're all basically speaking with one voice in terms of the merits of these cases. And I think the public needs to know that, because it's easy to get to attack someone who's seen as a liberal law professor for making these claims. But when it's a joint type of statement, I think that is a lot more forceful, and I think we need to highlight that fact.
Ned, I know you were thinking of a point.
Yeah, I want to go back to Justin's first comment, which I mostly agree with and agree emphatically with. But there's one way in which he talked about us as the public or the voters being hacked, which worries me, because it's not the first time that metaphor has been used to talk about disinformation, and I've seen it in print and elsewhere. But to me, it's been a source of concern from well before Election Day this year, that we've kind of lost our bearings as a society in thinking about how we know when we have a valid election and when we don't. No question, Russia did attack us, and they attacked us through disinformation. But as Justin properly said, they didn't mess with the tally of the votes. And I think analytically, we have to understand that that's how we determine whether we have winners or losers. There was this effort by significant figures within the Democratic Party. In a Washington Post column today, I just pointed out that notwithstanding the fact that Hillary Clinton conceded defeat, basically the morning after Election Day in 2016, she then gave an interview in 2019 where she talked about President Trump being illegitimate president because of what Russia did. And Jimmy Carter said essentially the same thing, that Trump had lost the election because of Russia. That is very irresponsible behavior by leaders of the Democratic Party that makes it harder for us as a country to figure out when we have valid presidents and when we don't. And some of the discourse that's occurred in the last week or two has been, oh, well, you guys did this to us, so now we're doing it to you. We've got to be able to get back to the point where we can recognize winners and losers based on accurate tallies of the votes. Now, I do think that disinformation, of the nature that we're seeing now, claiming that there's fraud when there isn't any, does have the danger of the public not understanding their own electoral process and not being able to identify when we have a valid result or not. And whatever metaphor or terminology we use about that, we do have to own that as a serious problem and figure out how to deal with it. And to Franita's point about civics education, I couldn't agree more. But I also think as we try to educate the citizenry better about this, both short-term and long-term, we have to focus on political leadership within both of our political parties. Normally we rely on the candidates for concession speeches and victory speeches, but now the concept of concessions has to come from the party as an institutional entity. The Republican Party, like the Democratic Party, is a player in our governmental process institutionally. And the Republican Party needs to acknowledge the accuracy of the result, even if their own candidate can't. And if we don't get to that point, the base of the party won't be able to get its signals accurately, right? Some of the civic education has to come within the party itself, so that it's not just the president's voice about what happened, but it's the other leaders of the Republican Party, for the sake of democracy going forward, two-party democracy, saying, you know what, we lost this time, we'll win next time. This is how it goes. So that's my contribution at the moment.
Well, hearing that also just makes me think about the importance of some norms here. We often have made the distinction between what are official results and when we get them, and what are simply media predictions and so forth. But there's yet a third dimension, which is not just the official results as compared with the predictions, but there's the whole area of norms. And we've seen really unprecedented departures from norms in this election. And it includes, in my view, ways in which many people have said accurately, in a very narrow sense, well, Trump has the right to let these courts play out, or the court suits play out, or even Trump has the right to speak to the county canvassers in Wayne County. Well, that's not really what's at issue, is whether there's a legal right to that. It's what protecting that right in an excessive way does to undermine the entire system and destroy the norms with which we've functioned. And that leaves me agreeing with essentially what many of you have been saying so far, and still a little at sea about what we do, how we recover from this. I like very much the notion that we ourselves try to educate our students and the broader public and help media do a good job. And I would also have said, as a tribute to things we should celebrate here, it was not just that the election itself went well, as Rick Pilvis said earlier, but I think the media did a remarkably good job in the run-up to the election in helping the public anticipate and understand the way in which voting would play out, and the way in which the large volume of mail-in voting would delay the results and so forth. And there was some nervousness about that long beforehand that we managed to, I think, deal with pretty smoothly. But
can I offer a more despairing view than a lot of these comments about what we can contribute at this point?
Yep.
I'm not sure there's much we can contribute at this point, in the sense that, we have to do what we can do, but what we're talking about is, a significant portion of the president's supporters who have come to believe these stories about fraud and the like. We thought before the election, the only way President Trump would be able to play out this game, which we certainly anticipated might occur in advance, was if he had the support of the Republican Party leadership and the support of Fox News. One of the things we discovered very quickly after the election is the president doesn't need the support of Fox News. I don't even know if the Republican political establishment repudiated this story, how much of a difference it would make. But the one thing I'm sure of is we have zero capacity to reach those people and make a difference in how they think. I don't agree that the media has been both sides seeing these things. I think the media has overwhelmingly criticized all of these lawsuits from the start. It's said the accurate things, that they don't have any chance of affecting the outcome of the election. This has been said through much of the media. I don't think it penetrates to the people who most need to hear it, because we are now in a political culture in which people don't believe many, many traditional sources of authority and information. They believe the president. And I'm not sure what can penetrate that. I think there are things we can do going forward to try to make the system and the process work better. And, you know, I will certainly continue to write pieces and go on CNN and, you know, make the points I have to make. But I don't really believe that it makes any difference, because at this point, given where we are, because the people who read me and listen to me are not the people, and to any of us, to all of us. And I think even having some Republican election law specialists as part of a bipartisan, you know, kind of effort, I mean, I'm not against it, but I would not deceive myself into believing that that is likely to penetrate where it needs to penetrate to help people get deprogrammed from the idea that there's a massive amount of fraud and that the election is illegitimate. I mean, to me, that's the reality. And I just want to dissent from the happy idea that we can do something significant to cut into that, because I just don't believe it.
Lisa?
So I share Rick's frustration. That being said, I would not throw away my umbrella because I'm not getting wet, or whatever variation of that metaphor you want to adopt. I mean, I think that if people with expertise in these areas are not going out and talking to people either through our own platforms, or if people with other platforms want to consult us, or they want to have us sort of appear on various things, if that work was not happening, I fear that what we would have, it would be much, much worse than what we have right now. So it's just, I mean, I think that things very much can get worse than what we're seeing, in the second half of November 2020. That being said, I share your frustration, and I think that, for example, if a number of different law professors were, for example, if we had 5,000 law professors signing a memorandum saying that we think that Joe Biden won the election, I don't think that would make any difference at this point. But I think the work of educating people, I think, is actually very important and does a lot across the society. The other thing I was hoping to say really quickly was that Steve was talking about the importance of norms, and I certainly agree with the importance of norms and how they're being undermined. I also just wanted to note, though, that sometimes what I feel like we're talking about is actually goes further than being a norm, and is actually a legal issue where there's just not an effective enforcement mechanism. So, for example, does one have a right to file a lawsuit that complies with the relevant substantive and procedural requirements? Yes. Does one have a right to knowingly file a baseless lawsuit? No, actually, technically that is not legal. That is not consistent with the law. And then likewise, I don't know why the president has asked people from Michigan to come out and is calling sort of election officials in Michigan. I don't know for sure, but to the extent that somebody is trying to pressure election officials into rejecting the results of an election, that's not lawful at all. Rather, I think the problem there is that there's not an effective enforcement mechanism. So it's sort of a distinction without a difference, I think, to a lot of people, and that may be true. That being said, I'm starting to become more resistant to sort of agreeing that a lot of what's going on is technically legal. I think it's actually not technically. I think it's actually not legal. It's just not enforceable.
Michael?
So I totally agree with Lisa's point, and I'd take it even one step further, right? If you think back to Bush v. Gore, right? we had this law in Florida, intent to the voter standard, and that was pretty much it, right? How do you count ballots? You just figure out what the voter's intent was, right? And for years, that was fine. And for years, that's what people did. And then you had this hotly contested presidential election, and right, it was put under a microscope, and different people were viewing similarly marked ballots differently. And this became a constitutional issue. And now, right, as a result of that practice and norm, right, becoming the focus of this attention, right, the issue becoming constitutionalized. Now, right, if you look not just in Florida, but in every state across the country, there's a thick issuance, usually from the Secretary of State's office, that goes through every conceivable way somebody could screw up a ballot in that state, and whether or not it counts as a valid vote or not. And in this election, as a result of a lot of what's been going on, including a lot of what Lisa correctly points out, is certainly against norms, and quite possibly in some cases, right, against, right, under enforceable legal provisions, or perhaps unenforceable legal provisions in some cases. If you look at like an election code, right, there's really detailed provisions about how to register people to vote, how to maintain your registration lists, how to conduct voting. When you get to the end there, after like dozens and dozens of pages of all these detailed requirements, is usually, in most cases, then you do a county canvass, then you do a state canvass, then you certify the results, and the end of it. It's like the students running out of time at the end of the final and just writes like 3 sentences to deal with like the last quarter of the semester, right? And part of the reason for that is because, again, right, this has just been norms, right? Like most people are like, what's a canvass? What do you mean they're canvassing the results? I thought they announced the result. Like this wasn't something that previously had been a matter of public attention. It wasn't previously something that was a matter of public focus. And so as a result, the law left a lot to norms, and the law left a lot to practice. And these areas of the law are very, very underspecified and don't have a lot of enforcement mechanisms, precisely because, due to democratic norms, nobody's ever tried to put pressure on that aspect of it before, right? Just like until 2000, nobody had ever put pressure on that, right, intent of the voter standard before. So, I mean, I think, if anything, to loop to Rick Pilvis's question about like, what can we do? Probably for this election, not much. But I mean, for the future, I think at least one question is, how much do we need to lawify aspects of the electoral process that had previously been left to norms, right? Do we need like more specificity about what the canvas is supposed to be, what the canvas can't be? And I mean, quite frankly, even from the other perspective, for things like poll watchers, right? Like most poll watching, or not the election, the vote counting statutes, like they're very, I mean, that's part of the Pennsylvania Supreme Court's point. It's a vague statute, it's a general statute. There weren't detailed specific requirements that the state was violating. So, to the extent that you want to have a transparent process, right, that's another situation where you haven't had huge elections coming down to the poll watcher statute or the election counting, the vote counting statutes before. So that might be another area where you flesh it out with detail, right? You promote transparency, you try to cut off some of the crazy conspiracy theories at the root, right, by saying, look, everything's right out in the open, everything's there, everything's been visible. What are, as opposed to, trying to spin conspiracy theories because the people were 20 feet away, rather than being able to, actually like see what was going on. So I think that's the biggest takeaway from this. We're going to see at least the issue of, should law step in to replace norms, given how surprisingly fragile many of these norms wound up being once they were put under pressure.
Justin, yeah, go ahead.
So I just a tiny little thought to follow on Michael's. I don't disagree that there will be a lot more attention to lawifying stuff, and particularly where it involves discretion that the legislature has given to the executive, both federally and at a state level. I think there'll be a lot more attention to re-lawifying and pulling back some of that discretion in the years to come. I worry a little bit about that. On the one hand, yes, lawifying can serve to fence out the most egregious misbehavior. But to take Rebecca's point, where she opened this series, any tool can be abused. And if you lawify too much to guard against the most rampant abuses, you're actually going to end up cutting off your nose to spite your face in a lot of circumstances. So I think in order to avoid death threats to people who are counting the ballots, there might be a big cutback on transparency, very clear cutback on transparency. No, you don't have a right to be in X series of places in watching the count or something like that, to make sure that we don't have these legal fights afterward. That is ultimately, I think, potentially detrimental. I worry about some of the backlash to the worst behavior we've seen, leading to lawified, codified protections against the worst behavior that also don't serve us very well. I would love to see more of a mix if we can, and this is going to require what others have talked about before, a lot more responsible behavior from party leadership. That is codifying some protections, but leaving it to really firm statements by trusted party members about what they will or won't condone to govern against the rest. And the problem when we don't have party leadership stepping up in that way is the only recourse that people feel like they have is to codify, to overprotect in a way that might not actually serve our interests longer term. So to some extent, to the extent that misbehavior is not only being tacitly permitted, but encouraged by party leadership, I worry that's actually going to trigger a codification overcorrection in the future that's not actually going to serve the election system very well.
I think, most litigation, well, at least many pieces of election litigation give rise to ways in which the election laws could be clarified. The question is really whether it's an appropriate clarification, and even if it is, whether the legislatures are willing to do it. But there's lots of room to find lessons from this election where we could do some post-election revisions to our process. Josh?
So thinking along the lines of what Justin said, in the long, we can't do anything on this point for this election, or even maybe in the near term. But I do think that there needs to be a way to encourage more nonpartisan election administration. America's an outlier on this, and barring that, somehow encourage actions like Brad Raffensperger has been taking, where he's going against his party and he's upholding the rights of Georgia voters, and he's being very transparent. And I don't have any great ideas about how to encourage that action as compared to more partisan type actions from the election officials. And most local election officials, my sense have been really great. The Wayne County person is the outlier on this. But what could we do as an election law community to try to encourage more nonpartisan election official actions, or at least if they're partisan, encourage the type of actions that Raffensperger's been taking, is something that I think is a worthy project to think about.
I'll say something about the going forward part. There is going to be more talk about nationalizing more aspects of the national election process. I've had mixed views about that over the years. There's a lot to be said for the differences between states and different parts of states. On the other hand, I do think that seeing the incessant battles over the same issues across one state after another state in the regulatory, administrative apparatus, in the courts, state court, federal court, I think there's a lot more to be said now for trying to nationalize some aspects of the process. You've already seen a couple of Republican senators, put bills in. I've looked at the Hawley one a little bit. I haven't looked at the other one. But if there's going to be any serious effort to do this, especially if we have divided government, but maybe even if not, with a very fine margin of Democratic control in the Senate, there's going to have to be serious compromising to get something through that would be a sort of a stable national framework that would not be as subject to being turned around from election to election, because it takes so much heft to get things through Congress. The courts would probably be more respectful of than they are to individual state legislation. but it's going to take some real compromises, and that's going to be hard for the elected political figures to do with the constituency groups that are going to be pushing on them to not give in on anything. And so I think one thing we could do when it gets to that point, if it gets to that point, is actually, try to offer views about what reasonable trade-offs are, why even if we think, in an optimal world, the policy would be this, it's okay to take this slightly less version of that optimum in order to get these other parts of the bill through. I think we could actually be effective in that debate, if that debate ever really arises, because we can do things that elected politicians can't do, in terms of trying to sort of identify, what the system can live with, even if it's not what we personally would think is our first best choice.
Thanks, Rick.
Yeah, real quick, if you want an example of that, not to be too shameless promoting, but Kentucky's new photo ID law that was enacted this year, I think, is a good example of that. It's, in my view, probably the most mild form of a photo ID law where each side can feel like they got something, and it's not the optimal policy, but I think there's an equilibrium there. It's just one example of how that happened.
I had one thing here, which is that given the move to mail balloting, there is an argument for greater federal involvement that I don't think we had before because of the central role that the Postal Service plays. So that while I would think any series of election reforms responsive to the problems that we've seen this time would try to take the load off the Postal Service, try to have people, more drop boxes, more alternative ways to deliver your ballots, as well as real rethinking of the deadlines, right? I think both on the front end and on the back end, a lot of us on this call have written or talked about this, but having greater clarity on when ballots need to either be postmarked or received. But the fact that the Postal Service played such an important role in this election and was a lightning rod, I think argues for greater federal involvement than in a way that maybe even previously we hadn't thought about. Because if it ends up being that roughly a quarter or so, maybe it's a little less than that, let's say 20% of ballots went through the postal system. I mean, we often say in the US that we don't have a national election authority, but in an election where a hell of a lot of the votes are delivered by mail, the Postal Service becomes that national election authority. And so I think there is some compromise that could be fleshed out, if reasonable minds at some point prevail, dealing with also election observation. I think that right now having some standard rules about how, and you don't have to have people, and you could have videotaping. You could have if you look at the way other countries do it in terms of counting ballots, right? There are all kinds of ways to ensure transparency. And so that, if we do fight the last war, which is to say this election in election reform, you could see some compromise possible on observation, dealing with mail ballots, dealing with deadlines that Democrats and Republicans could each walk away with something.
Thanks, Nate. So we're coming up on an hour. We're going to keep going for a few more minutes for anyone who can stay with us. This is great and really a rich conversation. So Ned, I know you were ready to say something.
Yeah, thanks. Not surprisingly, those of us on the call will know that I'll turn to a historical perspective on some of what we're talking about. And, one book I want to mention is, the famous political scientist, Richard Hofstadter, so bring political scientists back into the mix, wrote a book called The Idea of the Party System, because ultimately competitive elections depend on, it is a norm of fair play among competing political parties. And that wasn't inevitable, and it wasn't even at the time of the Constitution. The development of the norm of fair competition between two political parties was something that developed after the first party system emerged between the Federalists and the Jeffersonian competition. The election of 1800 was a close run thing in terms of, peaceful transition of power. It really wasn't until we got Martin Van Buren and the development of the second party system between the Whigs and the Democrats that this notion of normalization of party conflict took hold. And I think we have to, this is to Rick Pilvis's point, I think we have to envision what, reasonable two-party competition, looks like going forward. If one of the two major parties is not going to play by any conception of the rules, then the enterprise can't go forward. But I'm not willing to give up on the concept of robust two-party competition. It's just that, the Democratic Party's view of fair elections is not the Republican Party's view of fair elections. And neither side is, certainly for the short term, is going to be able to be hegemonic. I believe, I don't know Senator Mitch McConnell personally, but I think he has a conception in his own mind, of fair elections that is different from, Senator Schumer's conception. We need to be able to bridge that, both for bringing this election to closure and thinking about what reform looks like. I think Senator McConnell appropriately observed this year that the process isn't resolved by networks. Somebody mentioned that already. It's resolved pursuant to the rule of law, which is a process taking place right now. So I think we can look and expect that when the certification happens and the courts achieve their results, as they're doing, as Nate and others have talked about, we should expect a bipartisan closure at the level of leadership about what our system actually produced. And if we don't get that, then I think we're in a pathological realm that we see the seeds for right now, but I don't think we're quite there yet. So I think what happens between now and December 14th, both culturally and in the legal process, is important, obviously, but what happens between now and January 6th is important. So I don't think the final story on this year is over. One last point. We've been talking about the role of norms and the role of law. One insight that I drew from the research I did for the Ballot Battles book is I imagine that there's a triangle. And to Josh's point about nonpartisan election administration, I think the way in which we do elections is a dynamic relationship between 3 points of a triangle, law being one, norms being two, and the institutions being the third, right? We need good law, we need good norms, and we need good institutions. They have to work together in a positive way. And when they do work in a positive way, we get better outcomes. When they work against each other, we go into a vicious circle. And that's where history can be helpful too. Our past has shown that we've had some very bad periods in American history, including the Gilded Age in the 1890s. I hope that our politics today is not a reversion of the 19th century, because most of us grew up in the later 20th century, which was a pretty good period historically. And we need to figure out how we can move forward better and not revert back to 19th century views. So with that, I'm sure there are other folks that would like to jump in. We're going to definitely have a hard stop no matter what at 3:45. If we run out of things to say before then, that's fine, but the floor is open for additional comments.
Are you able to take questions from the audience here, Ned?
I'm not sure we've enabled that feature, no. So we're going to have to, sorry, we apologize. This was just a discussion amongst ourselves. So, as soon as we feel like we've stopped, that's fine. But Charles, it looks like you wanted to jump in.
I have a question to throw to the law professors, which is, early in this process, there was speculation about the role of state courts and federal courts. I'm just wondering whether anyone wants to weigh in at this at least preliminary moment about kind of the involvement of the federal court system here. As an outsider, it seems that they've actually done a pretty light touch and let the state courts do their business. But I'm sure that someone will either disabuse me of that or provide nuances to that, how that's going. So I'd be curious. Anyway, I'm curious to know what real experts have to say about that at this point, at least.
Well, it's not just deference to the state courts. They've also, when they've gotten involved, issued pretty, significant and permissive decisions when it comes to respecting the electoral process. And so what's happening in Pennsylvania now, so you've got, you know, multiple federal courts and state courts involved in the Pennsylvania litigation. And so you've had, you know, a lot of that's gone up to the state Supreme Court there. And then you've got the Giuliani case, right, is in federal court, right? That we'll see what happens with that. But, you know, all indications are that the federal court, I mean, that's what's kind of interesting is the federal and state courts, I don't see a huge difference between the way they've dealt with this. And I see Justin nodding. I don't know whether you think that's right. That, I mean, part of it is because they've been rejecting all the same claims, right? So it's like, you know, that we haven't had the kind of variation that would allow us to kind of see, you know, if you put pressure on one versus the other, what would happen. The only, you know, the real interesting stuff, obviously, that happened in the pre-election period or in the immediate post-election period on with the U.S. Supreme Court and the Pennsylvania Supreme Court is kind of the curveball here. But on the election, the real nitty-gritty election fraud issues, they haven't differed that much.
But I would say this goes to Ned's idea that he's been kind of pushing. I would say that unless I'm wrong about this, none of the federal courts have said it's not appropriate for us to hear these cases. They've been rejecting them on the merits. And so that leaves open the door that Ned has been so worried about in presidential elections, that next time around or in some other case, the federal courts might actually think it's completely appropriate for them to make decisions about substantive constitutional issues before certification, or maybe postpone certification because they do make a substantive decision. So I think that we're still set up for this, you know, potential problem of competing court systems and election cases in a context where we can least afford it, which is the presidential election contest, which has these incredibly tight deadlines. I'm actually curious, by the way, so if I'm wrong about that, tell me, but I'm curious whether people think there's going to be any interest in Congress after this is done in postponing those dates in the Electoral Count Act, pushing them back, or are people going to think, no, that will just invite more litigation, you know, that it'll just allow the process to be dragged out longer. Let's keep this really incredibly compressed time schedule because we're still going to have these things going up to the last minute anyway, wherever we put those dates. It's going to be exploited by one side now that we're in this world. So I'd be interested in what people think about that.
I think to summarize the Democrats' likely position on this, which is that they don't want to extend it farther. This is just strangely enough, right? This was not predictable that it would fall this way. Obviously, Marco Rubio had his bill that would have changed some of the deadlines, but from my conversations with different folks, that it does seem like the Democrats there's no appetite to extend it. And especially, you know, this is what's always interesting about reform after a period of controversy, which is that there's, you know, it's not obvious that this is in long term better for one party or the other in the way you think about extending litigation. But now, since what's happening is that Republicans are bringing lawsuits that are seen as, you know, delaying the eventual certification or the meeting of the electors or whatever, then that's now become the Democratic position, which is no, we can't facilitate that. Where I think you could see, I mean, this is where you've written about this, we've written about it a lot of, you know, the fight over what to do about postmarks and about whether and the deadlines for receipt and mailing of ballots is where you could see some interesting, I think there's an opportunity for compromise here, but I worry that the Democratic position also has gotten too hardened by the way they've litigated these cases this year, and that we need to really just think about how important it would be to get some just clear rules in place that will make it so that you don't have to rely as much on the Postal Service and their, you know, the stresses that may befall them, and that, you know, it's more important that we have clear rules. And that's one thing that hopefully comes out of the evidence in Pennsylvania, is that there were quite few late arriving ballots. This is something, Rick, you were just saying.
Yeah.
And so that maybe it isn't such a disadvantage to groups that you might think are less likely to get stuff in on time. You know, it'd be much better to have some clear guidance here.
I agree.
So if I can, just 30 seconds of follow-up on two things that Nate just said that I also agree with. One, there is always a difference when you ask litigators whether they want clarity than when you ask campaign officials and organizers whether they want clarity. That you may well have different hardened positions on the side of litigators or entities in both parties, depending on whether you're asking a litigator or whether you're asking an organizer about what they think an acceptable compromise might be. Those are not always the same. The second thing is to Nate's point about the potential democratic response to a prolonged, or a prolonged actually puts an emphasis on it, to a longer period between election day and the meeting of the electors, extending that calendar. So right now, I think to the extent there is any frenzy or concern about the current litigation, I think vanishingly little and maybe none of it has to do with the merits. Nobody's asking whether any of these cases will win. They're only asking whether these cases will go on long enough to present some sort of procedural deadline. And I wonder whether Nate's impression of what the sort of learning from this last war may be correct empirically. But there's another story that could also be told, where if you removed some of the need to get an immediate answer because of the electoral count, you actually extended the deadline. Claims like the meritless claims we're seeing now might collapse on their own weight before we get to the point about worrying whether a procedural slip up in one place will delay the entire thing. That is, it becomes harder to play the game purely for delay purposes when delay is 2 months out than when it's 5 weeks out. And that might well be a different learning. I don't pretend to know how members of Congress will think about this issue. But right now, the litigation strategy is not to win, it's just to win for long enough to cause chaos. And if you extend the counting period and you extend the date on which the electors meet, that strategy is harder.
This was an issue. Hold on, I was getting feedback. This was an issue that came up when Senator Rubio had proposed his bill. One of the reasons that I was skeptical about extending the deadlines was whether it would really fix any problems as opposed to just trigger other offsetting corresponding adjustments, right? Like right now you have initial counts going right 24 hours a day. Right now you have court deadlines, right, being scheduled within like a day or 2 days or something. If it's like, oh man, we have till January, there's no rush, man. Let's go take a lunch break, take a few days to brief the case. I don't have to have the hearing now. I wonder to the extent that you give more breathing time, if just a lot of these processes where the timing is at least somewhat in the control of people who otherwise, right, would be working, 18-hour days or something, whether it just expands to eat up more of that time. And if then you have problems on the back end, now you have no wiggle room, right? Like if it's, January 2nd, right? And you have some sort of natural disaster or blizzard or something, and the electors can't meet that day or something in a particular state. Now you have like 3 days to try to sort it out and fix things. Or if you have a faithless elector vote, right, in a 268, 270 election, you have a faithless elector vote. Now you have 3 days to try to go to court and fix things. Like, again, like we're focusing backwards a little bit on the crises that happened this cycle, the crises that we were afraid were going to happen this cycle. There are all kinds of other crises we haven't even started, thinking about yet. That I hate to give up the wiggle room on the back end necessary, and again, right, give up some of that rushing to get through this stuff and get answers sooner rather than later. That some of these that the current setup encourages. I mean, at the end of the day, I don't know that there's like one objectively, indisputably correct answer. Everything's all a matter of just trade-offs and balancing.
So I'm going to use that as a cue to end on the note that things could be a whole lot worse if crises were the ones that we could imagine that didn't take place. So I want to thank, first of all, I want to thank Steve, who had to leave for a University Senate meeting, who, as I knew, did a great job moderating us. I want to thank all of you panelists for participating in a great brainstorming session and conversation that I think we clearly could go on for longer, but we won't, at least not today. And I want to thank our audience for bearing with us and listening in for the conversation. And let's hope that when we do reconvene in whatever format and whatever way, at whatever time, we can look back and think that we did survive this whole year. And maybe even to Rick Pilvis's first point, maybe we can eventually celebrate some of the things that were really worth celebrating about this unique election year. So with that, thank you all, and be well, take care, goodbye.